if you use any kind of computer program or AI to help you make a decision in the business, and that uses personal information and it might impact the rights of an individual, then you actually need to now disclose that in your privacy policy. So some of the use cases that I've found so far, it's probably the biggest in property management. You know, when tenants apply through different programs and we can then score their kind of affordability ratio, that's probably one of the biggest ones. And yes, we put the data in the back end often to kind of set out those ratios. But the law is saying if it even helps you a little bit, it doesn't have to make the whole decision for you, because obviously you go in and you check all the references and make sure that that is actually the right person, and you check their pay slips and all those sorts of things. But because it's scoring and helping you make a decision, and it really affects their rights, like their rights to housing, right? We really need to disclose that.
Welcome back to the Property Management Podcast. Thank you so much for being here. Now, I'll be honest, privacy laws, not exactly my favourite topic, but with AI, outsourcing and digital tools running so much of our industry, protecting data is more important than ever. And the worst part, most agencies don't even realise they're at risk until it's too late. Did you know that if you're storing tenant data incorrectly, sending information offshore without letting anyone know, or using AI-powered tools to assess something like, say, tenant applications, you could already be breaking the law. The latest privacy reforms in Australia aren't just small tweaks, they come with huge fines, tighter regulations and major changes to how we collect, store and protect personal information. Some fines could hit up to $66,000 per breach, or in the millions for serious violations. So what does this mean for real estate professionals, BDMs and property managers? And how do you make sure your agency is compliant before disaster strikes? Well, that's exactly why I've brought in Kristen Porter, founder of Ono Legal and an absolute expert in real estate law and privacy compliance. Kristen isn't just another lawyer. She's from the industry, a third-generation real estate insider. She understands the unique risks agencies face and has led privacy crisis response teams and helped businesses survive serious data breaches. So in this episode, we're going to cover off on a high-level overview of the new privacy laws and why they were introduced, the biggest risk that most agencies don't even realise exists, what these changes mean for property managers, BDMs and real estate business owners, the best practices and compliance steps you need to take right now to avoid massive fines, and what the future of privacy laws look like for the industry. If you're thinking, this sounds way too overwhelming, don't worry. Kristen is breaking it all down in a way that's simple, practical and actionable. So grab yourself a coffee, get comfy, and let's dive on in. Kristen, thank you so much for joining me on the Property Management Podcast. Before we dive in, can you share with our audience a little bit about yourself and what you do?
Kylie, I'm so excited to be here today. I've been following you for quite some time. For those that you don't know who I am, I'm Kristen Porter and I'm the founder of Ono Legal, and we're known as the real estate agents lawyers. I'm third generation real estate. So my grandfather started our family agency something 52, 53 years ago. And I grew up with real estate in my blood. I remember my first ever job was letterbox drops, and I got paid in McDonald's thick shakes until I worked out there was this thing called money. And anyway, over time, I ended up going to uni and studying law and held various different positions. But when I opened my law firm, I decided, real estate really is my family, and that's why Ono Legal specifically helps real estate agency owners to shield their assets, future-proof their relationships, expand faster and plan their exits so that you know that your ass is actually covered. And so we do a lot of buying and selling rent rolls. We're going to be talking about the privacy space today, which I know can be a little bit boring. However, it's becoming really, really important because tenants, owners, the general public are just, they're getting savvier as to what their rights are and they know their rights. And so we need to make sure that we're ahead of them in that game.
That is amazing. And likewise, I've been following you for a long time as well. I've sat in on webinars and different things that you do because your content, whilst it's really important, like the privacy law, it's really important, it's also really entertaining and you've got a really good, great, and I know you're a marketer as well, so you've put a really different spin on how things are done. So the respect is mutual there. Now let's talk about this unsexy topic that is really, really important for us in the real estate industry at the moment, the Australian privacy laws, and what do they mean for real estate and property management?
Yeah, and they're ever changing. So the government essentially has identified a heap of different areas in which they want to reform in privacy land, and they've just released what we're calling tranche one. So there are more changes coming. I do know that our government, the real estate governing bodies are definitely lobbying government because real estate is already so highly regulated. And whilst we all want to do the right thing, and I know most agencies do want to do the right thing out there, having that extra red tape, it's really hard. And that's why, I spent my summer break trawling through the boring new privacy bill, which actually passed just before Christmas. So you don't have to do that. And so there are changes now with the Act that we can talk about today.
Yeah, if you want to break down some of those changes, and I know there's a lot there, but what are the ones, I guess, that are going to be most detrimental to agencies, property managers, business owners? Because I know there's a lot of fines, heavy penalties if you get some of this stuff wrong or don't comply.
Yeah, so let's start with those fines because generally speaking, I always kind of thought the Privacy Commissioner, whilst I've got a lot of respect for them, was kind of a toothless tiger. They didn't have a huge amount of resources and they had to investigate. Like if someone made a complaint against an agency, for example, they'd have to go and investigate before kind of doing anything. These new laws give the Commissioner now powers to issue an infringement notice. And so what that means is an infringement notice is a bit like a speeding ticket, where the cops can just fine you because they saw you speeding, or fair trading, when they come and do an audit, they can just give you a fine on the spot. So the Commissioner can now do that. So they can see if your privacy policy is non-compliant on your website and just fine you. If you get a complaint, they will go straight to your privacy policy and they'll actually ask you to see the other compliance documents, which a lot of people don't know about. And these have been in for a few years. It's what's called a collection notice and also your data breach response plan. So a collection notice is more like a one-page thing that says, hey, we're about to collect your information, like to the public. And then it usually refers people back to the website. So these are really important to have out at any open homes where you're collecting personal data. A lot of agencies will laminate one and have it sitting, say, with the contract for sale or with any other brochures, if it's like a house for lease or what have you. So it's on display and that's your collection notice. That then points back to your privacy policy, which is on your website. And you also need this thing called a data breach response plan. Now, what that is if there's a data breach, that you've got a plan in place. And the Act actually says you need to show how you comply with those laws, and that's through that plan. And so the Commissioner, in every data breach or complaint situation that I've helped with, the first thing they ask for is those 3 documents. And so you need to be able to produce them immediately. So if you don't have those things, we should probably have a chat. But also if you do have them, they actually need to be updated now for these changes that have just come in.
Right. So at a bare minimum, we need to have those three documents in place. I'm fairly certain I probably don't have them in place. So I will be having a chat to you after the podcast recording today. Now, let's talk about then some other changes. What about if you're collecting and storing data, is there some changes around that?
Yeah, absolutely. It's the collection and storage. It's more around offshoring the data. And so what that means is if you're sending any data offshore, so let's just say you've got a VA and they're accessing your servers or they're accessing any kind of data that you have, even on your Australian servers. If you're using any software and their servers are overseas, most applications I know of, especially the big ones in Australia, do have offshore servers in the US, the UK, or the Philippines, or some other countries. So even though you might think you're not sending data offshore, chances are you might be. So what we have to do now are two things with this offshoring. One, in your privacy policy, we have to actually state the countries that we're sending data to. And secondly, we now have to make sure that the people that are providing us services, be it the VAs or these software companies, they actually have to promise to comply with the Australian Privacy Act. Or you might see the words Australian privacy principles in your contracts. So if that's not in your contracts with those providers, we need to actually get those contracts updated now. If those providers say they can't comply with the Australian privacy laws, or that they won't for whatever reason, then you need new providers now, because the Commissioner is very clear that a breach of them is your breach. So if they do something wrong with the data, it's on your head. So you want that contractual backdoor, so to speak, to hold them accountable to that.
Oh my goodness. Wow. So what else then? That's another scary, not scary, but another thing that we probably, most of us probably wouldn't even thought of. And I know a lot of agencies are using virtual assistants now. So is that as simple as saying, I have got in my privacy policy or statement, I use the services of virtual assistants based in the Philippines, and that covers me?
Yeah, definitely. And then you make sure your contract then with the provider of your VAs, or if it's directly with your VAs, you have a clause in there to say that they will comply with the Australian privacy laws. Whilst this stuff sounds scary, it doesn't apply to all agencies. I might just touch on that, because this is a question we get quite a lot. So generally speaking, if your agency has revenue of more than $3 million a year, then you definitely have to comply. There's no ifs, buts, or maybes about that. Now, if you're under the $3 million in revenue a year, technically at a high level, the Act says you don't necessarily need to comply unless you've kind of opted in a different way. Now, most of us have actually opted into the Act without knowing it. So most of the contracts that you have with your data providers, if you're using any national tenancy databases like TICA, like most good property managers would be, to do your reference checks and check backgrounds and things like that, all of those contracts, if you look at them, you've actually promised to comply with the Privacy Act. I think it's clause number 2 of TICA's terms. I'm not saying anything bad about TICA. They're doing exactly the right thing. If you look like clause 2, last time I looked, it's me as agency, I agree to comply with the Australian privacy laws. So I don't really see how any agencies in Australia really wouldn't have to comply, if that makes sense. So there has been a bit of confusion of, if I'm under $3 million a year, do I have to comply? And chances are you've opted in.
Yeah. Would that also be through things like RP Data and Price Finder as well? Would we adopt those privacy laws through those programs as well?
I've not actually checked their terms and conditions, but any good lawyer that's acting for them would have put a clause like that in there to protect them as well, because especially if they're collecting data from you and they're using it for particular purposes, they want to make sure that they're protected, because they have to comply with the laws. So then they pass that obligation on to you to say, yes, when I give you my data or I'm using your database, I'm going to comply with these laws, because that's just kind of the flow-on effect, I suppose, at the big end of town, having to comply, and it kind of trickling down.
Trickles down to the rest of us. Yeah, because that is actually, I have a lot of conversations with property managers and business owners who are using programs like RP Data and Price Finder to garnish, property owners' details. And then there's even programs like ID for Me out there as well. Can you share anything with us, anything we need to worry about, anything we need to be conscious of when we're using those external data platforms? Are you feeling overwhelmed and thinking about selling your rent roll? Don't worry, you're not alone, and HDNU is here to help. Whether you're ready to sell now or you just want to plan for the future, the friendly and approachable team at HDNU makes the process simple and stress-free. Hello, yes please. With over 30 years of expertise, they're not just about crunching the numbers. They genuinely care about helping you maximise your agency's value and get the best outcome for you. Their sales readiness bundle is like having a trusted advisor by your side. They'll work closely with you to assess your agency's key factors, create an easy to understand heat map of your strengths and opportunities, and then sit down with you for a 90-minute workshop to guide you on what to do next. They'll look at everything from rent roll earnings and rent arrears to compliance and team performance and explain it all in plain English. If you're planning to sell soon, HD&U can even handle the whole process for you, from finding qualified buyers to negotiating the deal. Their friendly, professional team takes the stress out of selling so you can feel confident every step of the way. And to get started, simply book in a meeting with the team today. Their link is in the show notes. They're here to help you move forward with confidence. If you're ready to be a super organised, focused and productive property manager, buckle up, because Colmio is about to revolutionise the way that you work. Colmio is the driving force behind property management excellence in residential real estate. Now picture this, a comprehensive end-to-end system designed to be the beating heart of your property management tasks, manage your properties, owners and tenants, and handle payments, inspections, and even marketing listings without leaving the platform. Colmio is designed to be an all-in-one solution to all your property management needs. And here's the game changer. Colmio isn't just software. It's been awarded the most innovative PropTech Scale Up in 2023. Yes, you heard it right. Colmio has been recognised for their groundbreaking approach to property management software. How good is that? So property managers, whether you're a seasoned pro or just starting out, dive into the future of property management with Colmio. You can book in a demo with the team today and go in their weekly draw for a Prezi gift card worth $100. All you need to do is to head to the link colmio.com/thatpropertymum, and Colmio is Kolmeo.
Yeah, so when you're using those external data platforms, just what you want to look for is making sure you're using reputable ones, because you cannot market to someone unless they've actually consented for their data to be used for marketing. And so what these bigger companies do when they collect data and things like that is they make sure they get that consent. It's probably buried somewhere in terms and conditions when individuals give data. This will be a space to watch, because the commissioner is much more now talking about informed consent. And so if it's buried somewhere, is someone really giving informed consent for that data to be used? So I think we do need to be really mindful of our models, and they may need to change in the future. This is not in yet, but the government's certainly looking at these data sharing arrangements or data purchasing arrangements. And that informed consent piece, I don't think is really there properly at the moment, but we'll see what happens in the future. Something else that has just changed as well is in relation to AI and the use of computer programs in making decisions. So this change isn't necessarily coming into effect until next year, so 2026. However, because we're updating all our privacy policies at the moment for the other changes, like the offshoring data thing we just spoke about, we're getting all of our clients to update this as well. So what this change is if you use any kind of computer program or AI to help you make a decision in the business, and that uses personal information and it might impact the rights of an individual, then you actually need to now disclose that in your privacy policy. So some of the use cases that I've found so far, it's probably the biggest in property management. You know, when tenants apply through different programs, and we can then score their kind of affordability ratio, that's probably one of the biggest ones. And yes, we put the data in the back end often to kind of set out those ratios, but the law is saying if if it even helps you a little bit, it doesn't have to make the whole decision for you, because obviously you go in and you check all the references and make sure that that is actually the right person, and you check their pay slips and all those sorts of things. But because it's scoring and helping you make a decision, and it really affects their rights, like their rights to housing, right? We really need to disclose that. Another one in the sales space that I've seen as well is the prospecting tools. So you have there's all these really cool tools out there that can help you pretty much narrow in on a street to say that is the house that's probably going to transact next. Um, there is an argument that that might need to be disclosed as well. So anything that helps you make a decision using computer programs needs to be put now into our privacy policies.
That's interesting. And I was worried about AI, and that was actually one of the questions I was going to ask you because, again, that prospecting stuff, that's all AI generated. Even our appraisals that we do are all, generated by AI now. We're sending out documents that are, collecting all the data out there and putting it into an appraisal template or a proposal template for us. So we can still do it though. It's just we've got to disclose it. I mean, I don't know anyone that reads the privacy statements anyway, but as long as we're compliant, if somebody comes and looks at our privacy statement online, who did you say, the commissioner or somebody like that will, yeah. So yeah.
And you've got, I mean, yes, we need our privacy policies for compliance, but I find they can actually really be helpful if you get complaints. So I remember, well, I've got a few clients, but especially when I was in-house for one of the other, larger brands, we would get tenants complaining all the time. Why did you give my data to the tradesperson? Why did you do this? Why did you do that? And if you can direct them back to your privacy policy and say, well, you consented when you signed up with us for us to be able to do these things, it can shut the conversation down pretty quickly. And especially around this use of AI, I think as it's evolving, I mean, we probably can't even think of the use cases that are going to come in the next couple of years, right? And like I said before, the public, they're getting savvier as to their rights. And so if we're disclosing everything, we're being upfront, like you said, we can still do it. There's nothing wrong with doing it. We just need to put it in our privacy policy and then point people to that if they've got any questions or complaints.
I've got to use a case example for you. So I survey my clients probably 2 or 3 times a year. And what I did last year was I uploaded all their survey responses into Chat GPT and asked Chat to, analyze it for me, give me what's working, what's not, where's the gaps, what do I need to improve. And then from there, it told me that communication was an issue with my clients. They weren't happy with some of the communication. So then, I've got it to generate, a whole heap of communication plan and, what should I be sending them? When should I? And I've put all that data in and, into automated emails and stuff like that. Is that an issue? Because it's helped me make a decision on, I guess, improving communication in my business.
Yeah, that is so cool. I think I'm going to have to try that one. As it comes to privacy, it just comes back to, does that decision impact the rights of an individual? In this case, maybe not. So then that wouldn't have to go into the privacy policy. Like, so for example, using the AI to write blogs or things like that, that doesn't need to be disclosed. It's more that, does it affect the rights of an individual from a decision that you've made?
Okay, that's good. That's good to have that clarified then. Any other major things that we need to be aware of that could affect us on a day-to-day running or operations of our business?
Look, there were a heap of other changes in the Privacy Act, but they're more procedural things in the back end if things go wrong or what have you. There is a new tort. So a tort is a fancy legal word for a civil wrong. So like negligence is a tort, for example, as opposed to a criminal wrong. So what that means, instead of an individual having to trot off to the privacy commissioner, complain about you, they come and investigate and decide if they're going to do something or not, the individuals can now sue us directly. So if you've done something bad with someone's data, let's say it was a data breach, or you've just caused them loss in some way, then they can actually come and sue you directly now. They can bypass the privacy commissioner. So again, I haven't seen any of this yet in action because it's only been in force for a bit over a month, maybe 2 months. So there is that as well. So there's nothing that you necessarily need to do apart from comply, but it's more just to know that you can be sued directly now.
And so what could they sue us for? What would be an example of one of those data breaches that somebody is likely to or could potentially sue us for?
Yeah, so let's say you did have a data breach. I've dealt with quite a few of them. And let's say that there were financial information involved, or there was data that could have someone steal their identity. And let's say their identity was stolen, or someone emptied their bank account because their bank account details were leaked, then they could sue you for that loss, if that makes sense. So think about, or even think about some of those big breaches was like Medibank, and that was, medical information. And imagine if your medical information got out there and then you lost your job because something, I don't know, you had a mental health condition or something like that. Like that's really extreme.
Yep.
But it's more, yeah, with the real estate agencies, it's probably mostly, can someone steal someone's identity with that data, bank and financial records? So it's really, really important to only hold the information that you really need to hold. And the Commission has been telling us that for ages. Only collect and hold the information that you absolutely need.
Okay. So I guess the thing that's coming to my mind at the moment in terms of that data collection is, I guess, tenancy applications. When all that comes in, like, what do we do with that data now? Are we meant to get rid of it within sort of 30 days or something? Is that?
Each state and territory are reviewing all of those practices. I think in several states, bills have been introduced. So my understanding is there's a couple of states that are saying if a tenant's unsuccessful, get rid of the data. I think there's the quickest one. I think I've seen 3 business days. I can't remember which state that is off the top of my head. But so there is reform coming through, not the National Privacy Act, but this is coming through, I think, the residential tenancy laws in each state. Half the states haven't even looked at it yet. But I think Queensland, Vic, and New South Wales perhaps might be a bit ahead of the curve. The laws aren't in effect yet. And I think there's also saying then for successful applicants, different states are different, but it's in between 3 and 5 years after the tenancy ends that you need to keep it for. So that's a watch this space part at the moment. Sorry about that.
No, that's all right. So how can you support any business owners that are listening to this now thinking, oh my goodness, I've got no idea where to start or what to do? Yeah, I know you've got a few ways that you can help people.
No, absolutely. We've got 2 main ways that we can help people. So the Privacy Commissioner, in their framework that they've produced, is saying that all businesses really need to have an audit and to review their privacy practices as well as their policies. So we have launched a privacy health check where we'll come in. We sit with you for an hour. We talk about all the different privacy stuff, where your data's sitting, and work out from there what we need to analyze further. And then, of course, we can then prepare that privacy suite for you. That's on the custom basis. We also have a guided DIY option. We have an online template store, and on our website, onolegal.com.au, at the top, there's a template store tab. And under that, you've got privacy. And we have our privacy must-haves pack, which is in that store, that has all those documents we spoke about. So the collection notice, the privacy policy, the data breach response plan. But we've also got what we call a nice to have, which is the employee handbook. It shows your employees how they need to comply on a day-to-day basis. They're the ones at the front line. They're the ones collecting this data and using it. So it's really important that they understand how to use it. We've also got a resources tab on our website. We've got a heap of free resources. We've got a privacy super guide that can be downloaded, and we've got some other more in-depth privacy trainings. But if you wanted to have a chat about your privacy, we offer a free 10-minute chat. And again, that can be booked in through our website as well.
Amazing. Thank you. I'll share the links to all of that in the show notes. And I've used multiple services of yours, and I think I have actually used every one of those services, and yeah, the value is amazing and so easy. And what is sometimes really complicated for some of us business owners who I like the marketing, not the business and the numbers side of things. So people like me, it can get a little bit overwhelming having to deal with that. So you make it so simple to support us. So if anyone wants to follow, learn more about you, of course, I will share links in the show notes. Social media, what's the best place for them to find you there?
We're on all the platforms, me personally, plus Ono Legal. So we're on Instagram, we're on Facebook, LinkedIn, and I'm even on TikTok.
I know, it's very good. I love it. And also, I forgot to ask you one of my signature questions, which is about personal development. Can you recommend a tool, a resource, podcast, book for our audience?
Well, I mean, your podcast comes to mind as the obvious choice. But for me, oh, that's a hard one. I follow a lot of different people. You've really put me on the spot there. But the thing that I'm working on at the moment is more mindset and not getting so caught up in what other people think. So I've actually just started listening to Mel Robbins' new book, the Let Them theory.
Yep.
Let Them. So I've only just started that one, but I'm really excited to get into it because I'm usually looking at more technical kind of marketing or law stuff. So this one's a new one for me that I'm looking forward to.
Yeah. Oh, look, everything starts with mindset. I'm constantly working on my mindset. It is like a daily practice and struggle for me. So I can totally relate to that one, and good on you for doing that. Thank you so much for joining me on the podcast. I'm super grateful for everything that you do for me and for everyone in the industry. You are a superstar.
Oh, thanks, Kylie. It's been really great having a chat with you.
Can I ask you a quick favour before you leave this episode? Now, we all know how important reviews are for businesses these days, and mine is no different. If you could spare just a minute to follow, rate and review this podcast, it would mean a lot to me. In fact, what would get me super excited is if you share this podcast with someone in the industry who you think might need to hear some of the episodes right now. And if you'd like to find out more about working with me or any of the products I have to help you start, grow or scale your property management business, head to my website, thatpropertymum.com.au, or check out the links in the show notes.